Let me tell you about the morning Diane Kowalski stood in front of 14 concrete planters, each one weighing over 800 lb, and realized she had absolutely nowhere to go. 23 homes behind her had been without power for 14 hours. The utility crew had packed up and left, not because the job was impossible, but because the only legal access point now sat behind a wall of concrete on private property. She called my number. I picked up on the third ring. I said, "Submit a formal written request. I'll review it within 14 business days." Then I hung up. That was the result. Now, let me tell you how we got there. My name is Marcus Webb. I have spent 20 years reading structural drawings for a living, blueprints, survey plats, load calculations, utility schematics. I see the world in measurements, so when I say the fence that appeared on a Tuesday morning was wrong, I do not mean it felt wrong. I mean it was mathematically, legally, documentably wrong by 1.2 m across 28 m of property line. But I am getting ahead of myself. Let me start where every ordinary story starts, with breakfast. Lily was asking about the weekend, something about a school trip to the botanical garden, and I was half listening the way fathers do, when they are also reviewing a drainage spec on a laptop. The kitchen window faced east, toward the narrow strip of land, running along the right edge of my property. It was unremarkable land, sparse grass, a few weeds, nothing worth looking at twice. I had looked at it every morning for 6 years without thinking much about it. That morning, I noticed it one last time in its original state, without knowing it would be the last time. I came home at 4:15 in the afternoon, and the strip of land was gone. Not gone the way land disappears in a storm or a flood. Gone the way land disappears when someone decides, without asking, that it belongs to them now. A construction crew in matching gray shirts was setting precast concrete fence panels into the ground, steady and methodical, as though they had every right in the world. The panels were already chest high on the eastern boundary. My eastern boundary. I stood on my driveway for a long moment, doing the kind of mental calculation that becomes automatic after 2 decades in the field. The fence was not on the property line. It was inside it. I walked over and asked the crew foreman, a tired-looking man with a clipboard, whether they had a permit authorizing construction on this specific parcel. He looked at me with the practiced patience of someone who has been asked uncomfortable questions before, then pointed at the HOA logo on the side of the work truck. "We're operating under instruction from the Homeowners Association," he said, and turned back to his clipboard. I looked at the logo. I looked at the fence. Then I took out my phone and dialed the HOA office number I had saved but never used. Diane Kowalski answered on the second ring, which told me she was already expecting calls. Her voice had the particular texture of someone who has rehearsed their explanation, smooth on the surface, load-bearing underneath. She told me the fence was part of an approved infrastructure improvement project, that the boundary alignment had been updated according to a revised community map from 2019, and that all affected residents had been notified through the quarterly newsletter. I had not received any notification. I told her so. She said she was sorry to hear that in the tone people use when they are not sorry at all. I said 3 words before ending the call. "I understand. Thank you," and my neighbor Ray Domings was watering his garden next door, watching the whole exchange with the expression of someone who has seen this particular play performed before. He came over after I hung up, wiped his hands on his jeans, and told me quietly that the same thing had happened to the Peterson family on Clearwater Lane the previous year. They had complained twice, received 2 formal warning letters about unrelated HOA violations within the same month, and gone silent. I nodded. I was not going to go silent, but I was also not going to make noise yet. That evening, I went to the storage shelf in my home office and pulled out a document I had not touched since the closing date 6 years ago, the original survey plat from 1987, notarized, stamped, and recorded with the Millbrook County Land Registry. I spread it flat on the desk under the lamp and got out a ruler. Along the eastern boundary of Lot 14A, exactly where the fence now stood, there was a small notation I had never paid attention to before, a dashed blue line running the full length of the parcel, with a label printed in 6-point type. Utility Easement Corridor, access from Lot 14A. I set the ruler down. I looked at that dashed line for a long time. Outside, I could hear the construction crew finishing up for the day. The sound of tools being loaded into the truck, the engine starting, The silence that followed. I made a cup of coffee and sat back down. Something had just shifted, though I could not yet name exactly what. The HOA meeting room was designed to make a point. I noticed it the moment I walked in. The board table was elevated slightly on a low platform, just enough to require anyone sitting on the resident's side to look marginally upward. The chairs on my side were standard folding metal. The chairs behind the table were cushioned. Diane Kowalski sat at the center, flanked by two council members, whose names I would learn later. The lighting came from a fixture, positioned to illuminate the resident-facing side of the room more directly than the board side. It was a small theater, and I had been assigned the role of the petitioner. I placed a thin folder on the table, a photocopied section of the 1987 survey plat, and 6 photographs I had taken of the fence installation. Each one time-stamped, each one showing the visible remnant of the original boundary marker stakes still partially visible in the soil. I told them, without raising my voice, that the fence currently under construction was encroaching on my property by 1.2 m across a span of 28 m, and I asked them to provide the legal basis for that encroachment. Diane opened her laptop and turned the screen toward me. The image showed a boundary map. It had no date stamp, no surveyor's license number, no county recording reference, and no notary seal. She explained that this was the updated community map reflecting a boundary realignment made in 2019, approved by the HOA Council in accordance with Community Governance Authority. I asked one question. What is the county land registry filing number for this document? She paused. It was a short pause, less than 2 seconds. But in a room that quiet, 2 seconds is a long time. She said the document was an internal planning reference, not a county filing. I wrote that down. A council member named Carl leaned forward and said, with the tone of someone offering friendly advice, that was actually a warning, that residents who created difficulties during community improvement projects sometimes found the permitting process for their own home renovations became more complicated. 3 people had just heard him say that. So had my phone, which had been recording since I sat down. I closed my folder, stood up and said, "Thank you for your time. I'll be taking the appropriate next steps." Carl looked at Diane. Diane looked at me. Neither of them said anything else. I drove home with the recording saved in 2 places, my phone in a cloud backup. And I thought about what Carl's comment actually meant. It meant they were not afraid of me. It meant they had done this before and it had worked before, and they expected it to work again. That assumption was the most useful thing they gave me that evening because it meant they would not be watching carefully. People who believe they have already won tend to stop paying attention to the details. That night I opened the Millbrook County Land Registry public portal and searched every document associated with my parcel and the surrounding Elmwood Estate subdivision. The 2019 boundary map Diane had shown me did not exist anywhere in the public record. No filing date, no document number, no licensed surveyor signature. What I found instead was something else entirely. A document from 1989, buried in the infrastructure records for the original Elmwood development, Phase 2. It was titled Utility Infrastructure Access Agreement, and it had been signed by the original developer and the Millbrook Municipal Utilities Commission. It specified in plain language that the eastern corridor of Lot 14A constituted a protected utility access route for the subsurface electrical distribution and drainage infrastructure serving 23 downstream properties. Any permanent structure within 2 m of that corridor required written authorization from the lot owner. I opened a new spreadsheet. In the first cell, I typed GFRC concrete planters 820 kg each, residential landscaping, no building permit required, entirely within private property boundary. I did not yet know exactly how I would use what I had found, but I knew that the dashed blue line on the 1987 survey plat and the 1989 utility agreement were not just records. They were a door and I had just found the key. Hold on. Let's just pause here for a second. A boundary map with no date, no surveyor signature, no county filing number, and they used it to justify building a fence on someone else's land. Then a council member openly threatened that man's future permit applications out loud in front of witnesses. What they did not know is that the man sitting across from them reads structural blueprints for a living and had been recording the entire conversation. I want to ask you something right now. Have you ever dealt with a HOA, a building management committee, or a neighbor who acted like the rules were theirs to rewrite whenever it was convenient for them? What happened and how did you handle it? Drop it in the comments because I read every single one and stay with me, because Marcus just found something in that 1,989 document that is about to change everything. Sandra Obi arrived at 7:45 on a Wednesday morning, carrying a GPS survey unit, a field tripod, and a battered leather case that had clearly seen several decades of property disputes. She had been recommended to me by a colleague in the civil engineering field, someone who described her as the kind of licensed land surveyor that developers and HOA boards did not like to see show up on a job site because she had no institutional loyalties and an inconvenient commitment to accuracy. She charged a flat rate, worked alone, and delivered court-admissible reports. I showed her the survey plat from 1987 and told her what I needed. She pulled on her work gloves, looked at the fence for approximately 4 seconds, and said, "Give me 4 hours." I watched from the porch for the first hour, then went inside and let her work. Sandra located the original boundary marker stakes using ground-penetrating reference and GPS coordinate triangulation, tied directly to the county benchmark system. She measured the actual position of the HOA fence panels relative to the legal property boundary as recorded in the original plat. When she came back to the porch and handed me her field notes, the number at the top of the page was 1.24 m. That was the depth of the encroachment. 27.6 m was the length. Total unauthorized occupation, 34.2 square meters of private property. She signed the report, applied her state license stamp, and wrote the date. "This is court-ready," she said. And I believed her. The following morning, I drove to the Millbrook County Land Registry office and spent 3 hours at a research table with Sandra's report, the original survey plat, and a records request form I had submitted the previous week. What the county archivist brought out was a file box I had not known existed. Inside were the original development approval documents for Elmwood Estates, dated from the late 1980s, including the full utility infrastructure access agreement that I had found a reference to online. The physical document was more detailed than the digital summary. It specified not just the existence of the utility corridor, but the exact subsurface infrastructure contained within it. An electrical distribution panel serving 23 downstream lots, 2 main drainage valves, and a fiber conduit installed in 2004. All of it accessible from one direction only. All of it requiring unobstructed ground-level approach from the eastern corridor of Lot 14A. There was a third document in that file box, and it was the one that made Sandra, who had come with me, go very quiet for a moment. It was a building permit registry for the Elmwood Estates HOA, covering all permitted construction within the community's common areas for the past 15 years. I ran my finger down the list of approved projects: parking resurfacing, perimeter lighting, the community pool renovation in 2017. The concrete fence panel installation, currently underway along the eastern boundary of Lot 14A, was not on the list. Not a preliminary application, not a conditional approval, not even a rejected submission. The HOA had broken ground on a permanent structure, covering more than 30 square meters, without filing a single permit, with the city building department in direct violation of Section 14.3 of the Millbrook Municipal Construction Code. I left the records office with 3 certified document copies and drove directly to the office of Tom Elias. Tom had been practicing real estate and property law for 22 years. His office walls were the color of old paper and smelled like a library, and he had the habit of reading documents in absolute silence before saying anything at all. He read Sandra's survey report, the utility agreement, and the permit registry extract without speaking for nearly 20 minutes. Then he set them down in a neat stack, aligned the edges, and looked across the desk at me. He said I had 3 independent legal actions available: civil boundary violation, criminal unpermitted construction, and breach of the utility easement agreement, with potential municipal liability implications. He said he could file the first motion that afternoon if I wanted to move immediately. I told him I did not want to move immediately. He raised one eyebrow. I explained what I had in mind. He listened without interrupting, which I appreciated. When I finished, he leaned back in his chair and said it was the first time in 22 years a client had turned down an immediate lawsuit in favor of something more architectural. Then he drafted a formal cease and desist letter, not demanding removal of the fence, but requiring the HOA to provide written legal justification for the encroachment within 14 days. It was not a first strike. It was a question with no safe answer. Vincent Harlow's response arrived on day 7, printed on HOA legal letterhead, with an embossed seal that I suspected was chosen specifically to look authoritative. The letter was 3 paragraphs long. The first paragraph asserted that the fence was constructed in accordance with the community's internal boundary, realignment map, and the HOA's governance authority over shared infrastructure. The second paragraph cited a clause in the Elmwood Estates Declaration of Covenants that granted the association the right to manage and maintain community assets for the collective benefit of all residents. The third paragraph expressed hope that the matter could be resolved through cooperative dialogue. There was no county document reference number. There was no licensed surveyor's name. There was no mention of the 1,989 utility agreement. Tom called me after reading it and said 2 things. The first was that the phrase internal boundary realignment map was a legal admission that no public records supported their position. The second was that citing HOA governance authority over shared infrastructure was irrelevant to a private property encroachment claim because my lot was not shared infrastructure. It was individually titled land that the HOA had no jurisdictional authority over whatsoever. They answered, he said, and in answering they confirmed everything you suspected. I wrote 1 line in my notebook that evening. They have responded. Now it is my turn. I spread 3 documents across my work desk at home. The survey plat, the utility agreement infrastructure diagram, and a manufacturer catalog I had ordered from a commercial landscaping supply company. The product was a GFRC planter, glass fiber reinforced concrete, cast in modular rectangular units measuring 1.2 m long, 80 cm wide, and 90 cm tall. Shipping weight per unit, 820 kg, when filled with landscaping soil. The catalog listed them under architectural site furnishings, which was the relevant category for municipal code classification. Under Millbrook's construction ordinance, decorative site furnishings placed on private residential property did not constitute permanent fixed structures and, therefore, required no building permit. No HOA approval either, since my lot sat outside the association's jurisdictional boundary by legal deed description. I planned for 14 units, spaced at 2 m intervals along the eastern boundary of my property, positioned precisely within my legal parcel, not a centimeter beyond it. I drew the placement on a scaled site plan using the same drafting software I used for client projects, cross-referencing Sandra's survey coordinates to confirm each unit's location relative to the certified boundary line. When I overlaid the planter positions onto the utility infrastructure diagram from the 1,989 agreement, the result was exactly what I had calculated it would be. The planters would sit directly in front of the only ground-level approach corridor to the electrical distribution panel and the 2 main drainage valves, not on top of them, in front of the access path. Any maintenance crew needing to reach that equipment would have to approach from one direction, through my property gate, with my written permission. The legal precision of it mattered as much as the physical effect. I was not obstructing a public utility. The infrastructure remained intact and untouched beneath the ground. I was exercising my right as a private property owner to place lawful decorative elements on my own land. The fact that the HOA had destroyed the only alternative access route by building an unpermitted fence through the utility corridor was not my responsibility. That was a consequence of their own construction decision, and consequences have a way of belonging to the people who created them. I ordered the 14 planters that afternoon, paid by personal credit card, and scheduled delivery for 10 days out through a commercial landscaping contractor with no prior relationship to anyone in Elmwood Estates. Before confirming the order, I called Ray and told him I was going to be doing some landscaping work on the east side of the property the week. I asked him if anyone inquired to describe it as a garden renovation. He looked at me for a moment with the expression of someone doing quiet arithmetic, then nodded and said he would have his phone ready if the documentation became necessary. That same evening, a message arrived from Greg Marsh, a HOA council member I had never spoken to directly. It was brief. He said that at the most recent internal board meeting, Diane had told the council not to worry about me, that the type of person who files complaints and asks questions never actually follows through. He thought I should know. I read the message twice, set my phone face down on the desk, and looked out the east window at the fence standing in the dark. The smile I felt had nothing warm in it. Concrete planters 820 kg each, 14 of them. Placed perfectly legally on his own land. No permit needed, no HOA approval required. And Diane is sitting in a board meeting telling her council that Marcus Webb is the kind of man who complains but never follows through. I want to ask you something before we go any further. You now know what the planters are. You know where they are going, but I want to know what you think happens the moment that delivery truck rolls into Elmwood Estates with 14 blocks of reinforced concrete and a commercial crane. Does Diane come out immediately? Does she call her lawyer first? Or does she not understand what she is looking at until it is already too late? Drop your prediction in the comments right now before I turn the page, because the next chapter is where the trap stops being a plan and starts being a reality. The delivery truck appeared at the end of Larkspur Drive at 7:03 on a Tuesday morning, which I had chosen deliberately. Tuesday was the day Diane Kowalski held her weekly office hours at the HOA Community Center, 3 blocks away. I wanted her reachable, not absent. The truck was followed by a flatbed carrying the crane attachment, and the combined noise of both vehicles pulling up in front of my property was the kind of sound that draws curtains back and brings people to their front doors. Ray was already outside trimming. A hedge that did not particularly need trimming. His phone propped at an angle against a terracotta pot on his porch rail. We did not acknowledge each other. We did not need to. The installation crew worked with the efficiency of people who do this for commercial clients. No unnecessary conversation, no wasted motion. The crane operator positioned each GFRC unit according to the placement diagram I had provided, which I had printed at full scale and laminated the night before. Each planter was lowered onto its marked position, leveled, and backfilled with a blend of structural soil and gravel base. The sound each unit made when it contacted the ground was low and final, the way a gavel sounds at the end of a ruling. By the time the 5th planter was in place, I could see a silver HOA vehicle idling at the intersection 50M down the street. It sat there for 4 minutes before pulling forward. Vincent Harlow stepped out first, straightening his jacket with the automatic precision of a man who believes appearance constitutes authority. A council member named Carl followed, shading his eyes with one hand and looking at the planters with an expression that had not yet decided whether to be confused or angry. Harlow approached me at the property line, stopping precisely at it I noticed, which told me he had been briefed on the boundary issue, and asked what I was doing. I reached into the chest pocket of my jacket and produced a document package I had assembled the previous evening. It contained the certified survey report, the manufacturer's classification sheet confirming the planters as non-structural site furnishings, the relevant section of the Millbrook Municipal Construction Code confirming no permit requirement, and my property deed showing the installation zone as exclusively private-titled land. I handed it to him without explanation because the documents explained themselves. Harlow read in silence. Carl read over his shoulder. The crane continued working behind me, the 5th unit giving way to the 6th, the 7th. Harlow looked up and began a sentence with the words, "We may need to reassess." And I finished his thought for him by saying that his office was open until 5:00 in the afternoon, and that my contractor would be done by 4:00. Then I turned back toward the work. There was nothing legally actionable happening on my property, and we both understood that, which was precisely why Harlow put the documents under his arm, said nothing further, and walked back to the vehicle. Carl lingered for another moment staring at the growing row of gray concrete, and then followed. I heard the car door close. I heard the engine. I heard them leave. What I did not hear, because I was not meant to, was Diane Kowalski sitting in the passenger seat saying nothing at all. Ray told me about it afterward, that she had come in the 2nd vehicle, that she had sat with the window down watching the installation for nearly 20 minutes, and that she had not made a single phone call during that time. I found that detail more significant than anything Harlow had said. Diane was a woman who responded to challenges with immediate and overwhelming verbal force. Her silence meant she was looking at something she did not yet know how to categorize. By 3:47 that afternoon, the 14th planter touched ground. The crew packed their equipment, swept the street edge clean, and drove away. I stood at the end of the row and looked at what I had built. 14 uniform blocks of gray concrete, running in a straight line along my eastern boundary. Geometrically precise, aesthetically austere, and absolutely devastating in ways that only someone reading the 1989 utility diagram would fully appreciate. Lily leaned out her bedroom window above me and called down to ask what I was planting in them. I told her I was planting patience. She made a face and went back to her homework. 11 days passed without incident, which I had expected. The HOA's strategy in those 11 days was, I suspected, to wait and see whether the planters were a statement or a functional obstruction, to determine whether I understood what I had actually built. The answer to that question arrived on a Thursday afternoon at 4:22, when 23 homes in the eastern section of Elmwood estates lost power simultaneously. The outage registered on the Millbrook Municipal Utilities grid monitoring system as a fault condition at distribution. Node 7, which the system flagged for physical inspection. A two-man crew from the county electrical utility arrived within the hour, traced the fault location on their infrastructure map, and drove to the address indicated as the access point for Node 7. That snort's address was mine. The taller of the two technicians rang my doorbell and explained the situation with professional courtesy. There was a fault in the underground distribution panel. The panel was located in the utility corridor behind the eastern boundary of my property, and they needed to access it through my lot. I told him I was glad to cooperate and that I fully respected their maintenance responsibilities. I also explained that my standard procedure for any third-party access to my property was a formal written request, submitted on company letterhead, signed by an authorized representative, which I processed within 48 business hours. He stared at me with the expression of someone whose training had not covered this specific scenario. He said 23 households were currently without power. I told him I understood and that I was genuinely sorry for the inconvenience. He made 3 phone calls standing on my porch. None of them produced a signed document. He left. Diane's phone began ringing within the hour, and based on what Greg Marsh relayed to me later, it did not stop for the rest of the evening. The 23 affected homeowners were not calling to report a power outage. The utility company had already told them the cause. They were calling to ask why the HOA's fence installation had compromised the only service access corridor to their electrical infrastructure. That was a different kind of call entirely. Harlow reached Diane at 6:45 and told her something she apparently had not yet fully processed, that Marcus Webb had not done anything wrong. Every planter was on private property. Every unit was a permitted landscaping element. The utility corridor had been rendered inaccessible not by my planters, but by the HOA's own unpermitted fence, which had eliminated the alternative approach route that previously existed. The access problem was a consequence of a construction decision the HOA had made without a permit on land that did not belong to them. By the following morning, the drainage system serving 8 of the 23 properties had begun showing pressure irregularities, a predictable secondary effect of the maintenance crew being unable to reach the valve housings. A second utility team arrived and encountered the same barrier. By midday, the HOA had spent over $4,000 in emergency generator rentals distributed across the affected homes, and the number was climbing. Greg sent me the internal board meeting minutes from an emergency session Diane called that evening. The document showed that, for the first time in her 4 consecutive terms as board president, 2 council members had voted against her proposed response strategy. The minutes recorded no alternative resolution, just a 2-3 split and an adjournment. The evening of day 2, Diane drove to my house alone, no lawyer, no council member. She called my name from the sidewalk, standing at the edge of my property in the early dark. I was in the back garden with a watering can, moving unhurriedly along the row of planters, which by then had begun showing the first green shoots of the herbs I had planted. Rosemary along the south end, lavender in the middle beds. I did not go to the sidewalk, I said, without raising my voice, that all communication should be directed through my attorney's office during business hours. She stood there for a moment longer than was comfortable. Then she got back in her car. Later that night, I sat at the kitchen table with a cup of tea, and the kind of quiet that settles into a house when something that has been building for a long time has finally irrevocably arrived. Lily came downstairs for a glass of water, looked at my expression, and said I seemed different. I told her things were proceeding as expected. She said that was not what she meant. Let's just sit with that for a moment. 23 homes without power, drainage pressure dropping, $4,000 in emergency generators and climbing, and every single bit of it, every generator, every service call, every unanswered utility crew visit, traces back to one decision. The HOA built a fence without a permit on land that was not theirs, destroyed the only alternative access route to critical infrastructure, and never once considered that the man whose property they were standing on might actually understand exactly what they had done. Marcus did not cut a single wire. He did not block a single pipe. He planted rosemary and lavender and watched. Now, I want to know, where in the world are you watching this from right now? Because this story is landing differently depending on where you live, and I genuinely want to know. Drop your country or city in the comments. Chapter 7 is where Diane finally runs out of room. Vincent Harlow called Tom Elias at 8:15 on a Monday morning, which told me two things: that the weekend had been bad enough to end Diane's patience with waiting, and that she had decided a lawyer-to-lawyer conversation felt safer than another unanswered visit to my porch. Tom called me immediately after and described Harlow's tone as noticeably different from their previous exchanges. Less declarative, more exploratory, the vocal register of someone who has reassessed the terrain and found it less favorable than the map suggested. Harlow proposed a settlement meeting. Tom scheduled it for Wednesday and spent the intervening 2 days making sure we arrived with more paper than they had. Arguments. The meeting took place in a neutral conference room at Tom's office building. Diane sat across from us with Harlow beside her, and a yellow legal pad in front of her that remained blank for the duration of the meeting. She opened with an offer, $5,000 in compensation, and a commitment to review the fence alignment in exchange for immediate written permission for utility crews to access the corridor. Tom slid a single sheet across the table before she had finished the sentence. It was a damage calculation summary. 34.2 square meters of encroachment at assessed land value, unpermitted construction penalties under Section 14.3 of the Municipal Code, documented legal fees, and a line at the bottom reading indirect damages, ongoing utility disruption calculation pending. The total on the page was not $5,000. It was not close to $5,000. Diane's expression did not break, but something behind it shifted. The particular recalibration of someone who has just understood that the conversation they prepared for is not the conversation they are in. She said the figure was excessive and opened her mouth to continue, but Harlow put a hand briefly on the table in front of her. A small gesture, almost imperceptible. That meant stop. He asked whether there was flexibility in the timeline for utility access while the broader matter was being resolved. Tom said that was a question for his client, and both of them looked at me. I said I was open to discussing access arrangements through the proper channel, which was a formal written request reviewed at my discretion. Harlow wrote something on his own legal pad. Diane looked at the window. Then she changed register entirely. The measured negotiator stepped back, and the 4-term board president stepped forward. She told Tom that the HOA had 140 households, a legal defense fund, and the capacity to sustain litigation considerably longer than a single homeowner. She used the word protracted. She used the phrase community goodwill. And then she made a mistake that I think she had been trying to avoid making since she walked into the room. She said, "We have been patient with Mr. Webb's uncooperative posture, and that patience has limits." Tom opened a second folder. He placed a printed transcript on the table, a verbatim record of Carl's comment in the HOA meeting room, the one about permit complications for uncooperative residents. Below it was the audio file reference, time-stamped and formatted for court submission. He placed it without comment and let her read it. The silence that followed was of a different quality than the silences earlier in the meeting. Harlow read the transcript twice. He did not look at Diane when he finished. Tom then produced the final document, A letter from the Millbrook Municipal Utilities Commission, issued 8 days prior, confirming that the Utility Infrastructure Access Agreement of 1989 remained in full legal effect, and that any permanent obstruction of the designated corridor without written consent from the Lot 14A owner constituted a breach of a recorded easement, creating civil liability exposure for any party responsible for that obstruction. The letter named no party specifically. It did not need to. Diane set it down, aligned its edge with the table, and said nothing for 11 seconds. I counted. The community meeting Diane called 90 days later to update residents on the infrastructure situation was the most attended HOA event in the history of Elmwood Estates. Standing room, folding chairs borrowed from the church hall 2 streets over. She stood at the front of the room and offered the language she had prepared. Boundary review, community investment, unforeseen complications. From the 3rd row, a homeowner named Patricia Chen stood up and asked, with the steady composure of someone who had rehearsed the question carefully, whether the HOA had obtained a valid building permit before constructing the fence. The room went very quiet. Diane's pause lasted long enough for the answer to become unnecessary. The 2 council members seated beside her shifted their chairs slightly, almost invisibly, and Greg Marsh, sitting in the back row, recorded every second of it. Harlow called Tom on a Friday morning, 7 days after the community meeting, and the conversation lasted 40 minutes. Tom took notes on a yellow pad and called me immediately after. He said Harlow's opening words were, "My client would like to discuss a comprehensive resolution." That phrase, comprehensive resolution, is the sound a legal strategy makes when it collapses. Tom had heard it before. He said it meant they were done fighting and had moved on to determining the least damaging way to stop. We were in Tom's office within the hour, and by early afternoon, we had a framework that Tom described, with professional understatement, as unusually complete. The terms Marcus Webb required, not proposed required, were 5 in number. The first was that the HOA would contract at its own expense a licensed demolition crew to remove every panel of the unpermitted fence within 21 days of signing. The second was financial restitution of $11,200, covering survey costs, legal fees, and assessed land use compensation for the 47 days of encroachment. The third was a recorded covenant filed with the Millbrook County Land Registry, prohibiting any HOA construction within 3 m of my property boundary for a period of 10 years. The fourth was that the full agreement would be notarized and entered into the public county record visible searchable, permanent. And the fifth, which Tom later described as the detail that made him genuinely admire the architecture of the whole plan, was that the HOA was required to send a written notice to all 140 households of Elmwood Estates explaining the fence removal. The notice could not use the words strategic adjustment or revised planning. It had to state in plain language that the HOA had constructed a structure beyond its legal authority and was correcting the violation. Diane signed the agreement on a Tuesday afternoon. She did not make a statement. She did not request any modification to the language. Harlow shook Tom's hand at the door and said, with the weary brevity of someone filing away a professional lesson, that his client had not appreciated the depth of the property research that had been done prior to the planters going. And Tom said he would pass that along. I was not in the room. I did not need to be. 18 days after signing, 3 days inside the deadline, the demolition crew arrived at 6:50 in the morning. I made coffee and sat at the kitchen window in the same chair I had occupied on the morning I first saw the fence going up. The irony of the symmetry was not lost on me, though I experienced it less as satisfaction and more as a kind of geometric completion. The shape of the situation closing back on itself. The crew worked efficiently. Each panel came down in the reverse order it had gone up, loaded onto a flatbed with the same mechanical indifference that had accompanied its installation. By 10:15, the eastern boundary of my property was open again, the way it had been for 6 years before any of this began. The utility crews arrived the following morning with my written authorization, accessed the distribution panel and the drainage valves without incident, and had full service restored to all 23 downstream properties before noon. Ray came over that afternoon with 2 cups of coffee, and we stood at the east edge of the property looking at the row of planters, still in place, still mine, the lavender now knee-high, and the rosemary spreading in the way rosemary does when it decides it likes where it has been put. Ray asked me when I had known the plan would work. I told him it was the night I found the dashed blue line on the 1987 plat. The utility notation in 6-point type that nobody had looked at in 35 years. He asked why I had not told anyone. I said the documents had already done the talking. He handed me the coffee. We stood there for a while without speaking, which is the kind of conversation that only works between people who have known each other long enough to not need words. For everything. At the following month's HOA election, Diane Kowalski did not appear on the ballot. Her withdrawal notice contained 2 sentences. The 2 council members who had shifted their chairs in the community meeting won their seats with the highest vote totals in the association's history. Their first enacted policy required all HOA construction projects to obtain public permits and provide 30 days written notice to all residents before breaking ground. Lily asked me one evening, looking out at the planters from the landing at the top of the stairs, what I had ended up planting in them. I looked up at her and said, "Boundaries." She considered that for a moment, then nodded with the particular slow nod of a 16-year-old who has decided something is worth thinking about and went back to her room. And that is the complete story of Marcus Webb. I want to stay here for a moment before we close, because I think this story is worth more than just the satisfaction of watching a bad decision unravel in slow motion, though I will admit that part is deeply satisfying. The technical lesson first because it is real and it is practical. Know your documents. Not just that they exist, know what is in them. The survey plat from 1987, the utility agreement from 1989, a dashed blue line in 6-point type that nobody had looked at in over 3 decades. Those documents were always there. Marcus did not create them. He simply read them. Most people never do. Most people sign a closing packet, put the deed in a drawer, and assume that ownership means safety. It does not. Ownership means you have the right to protect what is yours, but only if you know exactly what yours is and where it ends. The deeper lesson has nothing to do with law. It has to do with the specific kind of power that comes from being the only person in the room who is not performing. Diane Kowalski performed authority for 4 consecutive terms. She arranged the furniture to make people look up at her. She used legal-sounding language without legal-grade documentation. She relied on the very human tendency to back down when an institution pushes back, because institutions feel permanent, and individuals feel small. What she never accounted for was a man who had spent 20 years measuring the difference between what something looks like and what it actually is. Marcus did not win because he was louder. He did not win because he was richer or better connected or more willing to fight dirty. He won because he was precise. He documented everything, acted within his rights, and never once gave his opponent a legitimate grievance to use against him. The greatest insult he delivered was not a single word he spoke. It was 14 concrete planters, perfectly placed, entirely legal, growing rosemary and lavender in the space where someone else's arrogance used to stand. If this story meant something to you, if you have ever stood where Marcus stood, holding the truth in your hand, while someone with a title told you that you were wrong, leave a comment below. And if someone in your life needs to hear this today, share it with them. I will see you in the next one.